Welcome to the Law Taster Day, sponsored by Clifford Chance. This event is for parents, teachers, students, international students, anyone that couldn't attend or wasn't nominated for the in-person event on Monday and Tuesday. You're very welcome, and we're really excited to have you with us and to give you a little presentation on what life at Oxford is like as a law student. We're going to have our first taster lecture with Elizabeth Drummond at 5:30. On to Clifford Chance, who are going to do a quick presentation on their law firm, how they became lawyers, if they were Oxford graduates, if they did a law degree, or if they didn't do a law degree and converted, all of that information. And then we'll move swiftly on to talks with our law ambassadors. We've got 3 law ambassadors joining us today. They're all undergraduate students currently on the program, and they're the best people to kind of answer your questions about what life is like at law. Our entry requirements are AAA at A level, or the international equivalents. If you look on the website, you'll see all of the countries' equivalents. You can figure out what is required for you. For the IB, which is another qualification that's taken quite widely, you would need 38 overall with 666 in higher level subjects. We don't have any required subjects for law, so you can take those that you really enjoy and that you excel at. Take any subject you like, as long as you have 3 predicted A's, then that'd be great for us. We have another subject or another program called Law with Law Studies in Europe. It's the same jurisprudence program. You do the first 2 years with us, and in the 3rd year, you'll go away to one of our partner countries, and you will study there for a whole year. So you will need the language of that country at A level or equivalent, unless you're going to the Netherlands where they speak English. So these are those countries that we have relationships with. So we've France, Germany, Italy, and Spain. You would need those foreign languages. And then the Netherlands, you just need to speak English. Obviously, that one's very competitive because you don't need to have the second language. So just keep that in mind. And then also keep in mind that if you do this 4-year program, you wouldn't be graduating with the people that were in your 1st and 2nd year, because you'd have that 3rd year out. Okay, so the application timeline. At Oxford, you're probably aware, we run things a little bit quicker than the rest of the universities. We have earlier deadlines. So, most of the UCAS process is exactly the same. You choose your courses. You then go on to do something a bit different, where you could choose a college to apply to. There are 31 colleges that take law students at undergraduates level. Or you don't choose a college, you choose an open application, and then we just allocate you to a college. Even if you choose a college, there's always spaces on our admissions process where you could be reallocated to a different college. So just bear that in mind and don't kind of get your heart stuck on one college, because it's very likely you could get reallocated. And then the next step is register for the LNAT. This is a big thing for me. Registration will start on the 1st of August, and you can register online. If you have any special examination requirements, like you have longer time usually when you take exams, you're going to need to fill in a form on Pearson. You can't register and book online. So you can register, you can start the process, then you'll need to fill in a form. It can take up to 2 weeks for them to ensure that you do have a location which meets everything that you need, and then get back to you with a date. So that's kind of something you want to be thinking about, planning ahead at that extra time. You don't want to be leaving it too late to kind of book your test. The test will start on the 1st of September, and they'll go through until the 15th of October for Oxford and Cambridge. That is a very firm deadline, the 15th of October, and we won't accept any tests that are taken after that date unless you have extreme mitigating circumstances that you've already received permission to sit the test late from us and from Pearson. So there's lots of steps in the registration that I'll kind of try and point out on the next slide. But then after that, you would be shortlisted maybe for an interview at 1 or 2 colleges at the university. You should get 2 interviews at 1 college, which gives you a chance to kind of mess up the first one with nerves and things like that, and then go into the second one even stronger. There is also a chance you could get another interview, so a 3rd interview, but at a 2nd college. So that just gives another college a chance to see how good you are. Then once we've done all of that and that's over, they happen around December time. In early January, you're going to get the final decision if you've been accepted or not, and that's your offering period. And then we have the final bit where you get your results. It's usually a very happy day and everyone gets their places. So that's the whole timeline summed up really, really quickly. This is all in a lot more detail. If you come to one of our open days, it's a lot slower process. I'm just trying to speed through things so we get to the good bits of the presentation. So on your UCAS form, just a few things to point out. Obviously, you've got your personal statement where it's your chance to kind of sell yourself to the universities and pick out what makes you special. But then also the references changed last year for UCAS. So this now has 3 distinct sections. And you can highlight this to your teacher. If you're a teacher on here, this would be great for you to know. So the first section is general statement about the school, how it's performing, that kind of thing. Then we're going to move on to extenuating circumstances. And this is something that universities will look at. This is what we're trying to see to get the whole picture of the student. So if we're looking at your application and maybe there's a grade which looks out of place, this is your chance to kind of say, yes, there's a grade that looks out of place and this is why. And then it just helps us understand and fill in the gaps really of the application. So if there is anything that teachers should know about you that you feel would impact your application, then you should let them know, and this is where they should put it. And then the last bit is them raving about you and saying how good you are. That's the last part of the reference. Nothing changed there. Okay, so I said when registering for the LNAT, there's a few things that I would like you to kind of keep in your mind when registering. So the first thing is there's going to be a tick box when you're registering. It's going to look like what's on the screen there. And it says indicate the universities you plan to apply to. You must tick at least one. But realistically, what you actually have to do is tick each university that you are going to apply to, because that tick box is actually authorizing Pearson to share the data with that university. If you don't tick that box by the 15th of October for us, when I export that data, you won't be on my list. So I won't be able to match you to the UCAS application. I'll have your UCAS application, but I won't have your LNAT application details, your essay, your multiple choice score. I'll have none of that. You won't appear at all. So tick the box. If in doubt, tick them all. If you haven't applied to that university, they're never going to look for your LNAT results anyway. So there we are. The next one is your UCAS PID, which is your unique identifier. You're doing both of these things at the same time. So you're applying for UCAS and you're registering for the LNAT. So there is a chance that when it comes to your LNAT registration, you're not going to have your UCAS ID yet. Put in all zeros. Don't make up a number. Put in all zeros. Then when you do get your UCAS ID before the 15th of October, update it, log back into Pearson, change the UCAS ID. This is really going to help me match those two systems together. And then finally, use the same name that's on your UCAS form on your LNAT registration. That again is going to help me match. So if your UCAS ID doesn't match for whatever reason, then I can go to your name and match it. If your name is David, don't shorten it to Dave on one of them. That's not going to work for the matching system either. So these are all things to ensure that we actually get your LNAT, because we do use both scores from the LNAT on your application when we're assessing you. So we introduced last year Astrophoria Foundation. It's a 1-year foundation year. So we have for law up to 8 places that we can offer. It's a later application deadline than everyone else. So it's the normal standard university deadline, which is in January. You can only apply for one course at Oxford or Cambridge. So you couldn't have this as a backup. You have to make your decision. You're either going to be predicted AAA or higher, and therefore you should go for the classic BA jurisprudence. If you're below AAA, but above BBB, so somewhere in the middle, that's the entry requirements for Astrophoria, and you should go for that as long as you meet all of the other requirements. So go onto the Oxford website, just type in Astrophoria Foundation or just even Foundation Year. It'll come up a whole different page, all of the entry requirements on there. Just make sure that you are eligible before you kind of use one of your UCAS choices. Once you've got a response from a program that you've applied to on UCAS, that's one of your choices gone, and we can't change you onto a different program. That's not how it works. Once you've had an answer, that's the end of your choice. So think about it beforehand if you fall into which category. If you fall into Astrophoria, or if you're actually predicted higher, then you have to go for the BA, really, jurisprudence. And then Opportunity Oxford is a university-run program, and you can't actually apply for it. So I'm going to tell you about it because a lot of people don't know about it, but it's not something that you apply to. It's when you apply to do your BA in jurisprudence or law of law studies in Europe, the university will then flag certain students from underrepresented backgrounds that they feel would really benefit from an online program just before you join, and the residential program that they put on. They put on 2 weeks residential just before you start your program. It's to learn lots of soft skills and just to make sure that you come into the program on, with all the skills that you need. Here's a few social media things that you can look out for and how to connect with Oxford. We've got our open days coming up on the 26th, 27th of June, and then again on the 20th of September. Highly recommend attending. Some people come and stay for the whole 2 days. Some people cram everything into one day. It's absolutely fine. At the law faculty, we'll be repeating the same sessions morning and afternoon on both days. So you'll have a presentation on admissions, a lot longer than what I just did, by our admissions officer, a coordinator, either Rebecca Williams or James Goodcamp. And then we'll have a taster lecture. We'll have law ambassador students for you to talk to. And then we'll repeat that again in the afternoon as well. We have a lot of people attending. We do ask that parents don't go into the main theatre. I will stream it into some other rooms for you, just so that we can give the students the full kind of feel of the Gulbenkian theatre, and ask their questions in person. So Elizabeth Drummond is going to do your presentation.
My lecture is going to be about Roman law specifically, but I am very happy to answer questions about Roman law, about the course at Oxford, about admissions. So my name is Elizabeth Drummond. I'm a fellow and tutor in law at Mansfield College. And today I am going to talk about Roman law. And as you can see from the title of my presentation, this is really important to me because the Romans invented my job, and because I think that Roman law has a lot to teach all lawyers. And that's particularly relevant to you folks, because as prospective law students, you're about to start on a time on your life when you learn the law and you're choosing where to do that. Roman law is a compulsory subject in the first year at Oxford, and one of the things I want to do today is give you an insight into why that is. So at Oxford we do teach Roman law, we make it compulsory in the first year, we teach it in English, and we teach it as a resource for better understanding modern law and where modern law comes from. So let's look at the first year course. It's called A Roman Introduction to Private Law. So it's focusing on Roman law as a means to understanding private law. So that's private law as opposed to criminal or other public law. And the difference between those is that private law is about the relationships between private individuals. So they might be people like you or I, or businesses, companies, and those sort of people between themselves. So it's not primarily about the relationships between people or companies, businesses, and the state. It's about relationships between themselves. So for example, it's about what your rights are if you make a contract with someone else. So if you're going to buy something, if you're going to be employed by a company, that's private law. Or if there's some wrongdoing aside from crime. So if you receive bad legal advice, or if you were given bad medical treatment, or if you were injured by someone else's carelessness, that would all be under private law. So let me show you the topics we cover in the course. So we look at the sources of Roman law, the way that Roman law was built up, which is really different from the English system. And it gives us an insight into how different legal systems can be built up in a different way. And we also look at property law. So that's who owns what are the rights you can have in things. You can own them, you can have other rights over them. For example, if you're thinking about people's relationships with land, so someone might own their house, but they might have a mortgage over it. Maybe their neighbour has a right of way over the land. So all of those are different rights you can have in land. And then contract, that is about which promises between people are enforceable in law. And then the law of private wrongs. So that's when the law looks at something and says, well, you shouldn't do that, or you shouldn't let that happen. And in Roman law, that might mean that a penalty was enforced for the victim, or compensation was paid to them. And we look at how Roman law developed in those areas in that period, that long period there, between the 5th century BC and the 6th century AD. But I said that the Romans invented my job, and I will say I have the best job in the world. So I get paid to read and write and talk about law. And we look at things like where it comes from, how it's made, what it is, the principles it's based on, what the law should be. And I say the Romans invented my job because they also had people who were paid to do that. And they were called jurists. And their occupation was writing about the law and teaching law and advising on what the law was for their case. And they had a huge impact in Roman law in their time, and they left a huge legacy in later Roman law, and you can see that right up to the present day. And I think that Roman jurists and what they did for Roman law are really interesting. And I think that knowing about Roman jurists gives you an insight into Roman law and modern academic law. So in order to give you an insight into the jurists, I'm going to talk about who the Roman lawyers were in the Republican period. So that's the period between about 509 BC and the later part of the 1st century BC. So here we have some of the Roman lawyers. Here are the officials who are responsible for putting forward legislative proposals to the assemblies, those are the legislative bodies, and they create legal actions for claimants. So if you feel like you need to go to court over something, you go to the official and they give you an action that you can bring. So they give you a proposition to put to the judge to say, I entered into a contract of sale with this person and I didn't get what I was promised under that contract, and they will give you an action for that. One of the things that really strikes people about this is these officials were not legally trained. They were lay people. If you wanted to be elected as a legal official in Roman law, then you needed to run for office, and you wouldn't necessarily get this job. You might get a different job in the Roman political structure. So these officials were not generally legally trained at all. You also have in the Romans, the Roman lawyers in the Republic also include judges. The way that the Romans run their legal cases is that every case that comes up, you select a private citizen from the register to act as the judge. It's a bit like jury services in our times. Judges also were not legally trained because they were private citizens and they were selected to judge each particular case. So what you will notice from this is that this is really different from our system. We expect judges to be legally trained, and we expect that when a judge decides a case, that there will be a system of precedent for them to follow. And if they are deciding the case at quite a high level, we expect that their judgment will create precedent for lower judges to follow. But in the Roman system, it wasn't like that. The judge would look at the question that was sent to them in the pleadings, and they would say, yes, this person needs to pay up, or no, this case is not proven. And that's all they would say. They wouldn't give reasons. So what you'll notice is nobody is legally trained and everybody is doing a different job within the system. So what about the jurists? The jurists are also private citizens, but they are legally educated. They operate as writers and teachers and advisors. They are people who have the privilege to use their time and their money to become educated in the law. And they really care about what the law is and how it develops. And one of the things that jurists are most known for is the sheer amount that they wrote. So they wrote books and commentaries and ideas about the law and how it should develop, how statutes should be interpreted, all of those things. And they will write advice to litigants, but they also just sit down and write things that they are interested in. One of the big questions that people ask me is whether writing's legally binding on a judge. Now, people nowadays really debate about this. And some people will say that in the early empire, when the emperors were starting to get a footing, that the emperors would say, these jurists, you should listen to them. And that created a sort of system of formal precedent, a bit like in our system where the Court of Appeal or Supreme Court give judgments which are binding on the lower courts. Other people say no, because that's not something that the system needed. Jurists had always had this sort of natural authority through the fact that they were educated about the law and they knew what they were talking about, and they took lots of contrary opinions into account when they were writing. And so if a judge who is not legally trained sees an opinion from a jurist, they are likely to think, well, they know more than me about the law, so I'm actually going to follow what they say. If the jurist disagreed, then the judge would have to make up their own mind anyway. So this is something that people still debate about. One thing that we do know is that the jurist's work had a profound impact on Roman law, and it also has a big influence today for reasons that I'll get into. And one of the ways we can see that is by looking at the jurist's work against this sweep of history that I've talked about before, this 1,000 years period that we're covering in the first year course. So I'm thinking about this long period that I mentioned before, and the reason I went back to the 5th century BC is that I always start with the 12 tables. This is the first written statute in Roman law. It's called the 12 tables because the statute was engraved on 12 bronze tablets, which were set up in a public place for everyone to look at. It was the first time in Roman law that a statute had actually been published, so that people would know what kind of law applied to them and what law they could take advantage of. And then it runs all the way up to the reign of Justinian in the 6th century AD. And the reason we focus on Justinian's reign is that he masterminded a huge codification of Roman law. And I've put that in quotes because it wasn't a law code in the modern sense. So if you've heard about the French Civil Code, the German Civil Code, the Corpus Juris Civilis, which is called that because it's called the body of the Roman law, it's not like that. It's not as simple or brief. It is more like a pocket law library, is what one of my predecessors once called it. It's 3 books that contain what Justinian said was the Roman law of his time. And Justinian didn't do that perfectly, but it was what he aimed to do, was to take all of Roman law and put it into 3 books. Quick and simple was Justinian's hope, that it would be possible for people to know the law by reading these 3 books. One of the jurists that we think about, particularly at Oxford, was active in what we call the classical period. And I can locate this by reference to the Emperor Augustus. That was when his reign was, 14 BC to 27 AD. And therefore, that's what kicks off the first stage of the empire, which is the Principate. And the second stage of the empire is known as the Dominate, because that's the time when the emperor really says, I am the person who governs this empire. It is only me. I am the only law giver. I am the only person who is in charge of the state. The last phase of the Republic and the Principate period is known generally as the Classical period. It's the classical period of Roman law. It is a time of great legal development and a lot of writings of jurists. And the individual jurists that we know today from their writings were the ones who were active during this period. And that's when the jurist I mentioned before, Gaius, was particularly active. And we know that he wrote a textbook for first-year law students in his day called Gaius's Institutes, and we located at 161 AD. And that's particularly important to me and to the Oxford course because it's one of the set texts that we use. We use a translation of it. It's a very short book. It can be compressed into a small A5 booklet. And it is an attempt by Gaius to explain the very basics of Roman law, to give a whole overview of all of the Roman private law for his students. And one of the things Gaius really cared about was explaining that in a way that made it easy to learn, and also looking at what sort of distinctions matter. How should we arrange law so that we can learn it better, so that we can do better in working out which principles we should have? It's also special because we have a virtually complete manuscript of that book in its original text. So that's a statement of Roman law as it was in the mid-2nd century AD. And that's really important because although Justinian did collect together a lot of earlier writings when he compiled his law library, he did it in a very selective manner, and he edited a lot of books so that their original meaning becomes uncertain. But now we know that we have an original manuscript of Gaius's from the 2nd century. And so when we look at Justinian's texts, we can sometimes see the classical law running through them because it hasn't been completely eliminated. And you can also compare how the law developed to Justinian's time. And one of the things that we do in the course at Oxford is we also use as a set text the Institutes of Justinian. So Justinian takes the Institutes of Gaius and makes a new edition of it. He does copy a lot of material from Gaius where he feels he can't improve on it, but he does make a lot of other changes to try to represent the law of his own time, to give due regard to the statutes that have been passed since 161. There's been a lot of development. Some of that development Justinian was himself responsible for, and so he updates it. But we use both of those as set texts in the first year course at Oxford to help us to investigate Roman law and look at how it developed. Now let's look at the role of the jurist in Roman law, and I think the easiest way to do that is to look at Roman sources of law. So these are the Roman sources of law. There are statutes, so legislation, very much as we have it in modern English law. They have rules on what claims can be made in court. So we were looking earlier at the fact that if you need to go to court, if you feel that someone has done you a wrong or hasn't come up to what you expected of them, you can go to the official and get pleadings formulated so that you can go to a judge and get your case heard. And also development by the jurist. Now, let's look at how these developed over time. But one thing that I think you will notice immediately is that in this list, there's no place for case law. So an English lawyer would say, well, hang on a minute, what about the decisions of judges that are coming into precedent? But if you remember what I said earlier, the Romans actually didn't have a system of precedent. So that function that we associate with our English courts in terms of developing the law and interpreting the words of statutes, that wasn't done by judges in the Roman system. So if we look first at statutes, these were originally made by assemblies of the people. The official would come and say, this is the legal proposal for legislation I put forward before you today. And the assembly of the people would say yes, or it would say no. Very early on in the empire, after Augustus took over, the assemblies were got rid of because it wasn't compatible with the growing power of the emperor. The emperor was regarded as a direct legislator from around the mid-2nd century AD. In between, the Senate, which had been a very important Republican political body, briefly took over as a direct legislative body. But as soon as the emperor had consolidated his power, he became the sole lawmaker, the sole legislator. There were then rules about what claims could be made in court. During the late Republic and the early Empire, these officials would make new rules about what claims could be made in court, and thereby they developed the law as well. So they said somebody can have a claim in this case, which has already been provided for by statute, and also in this other case, which is quite similar. It's not exactly covered by the statute, but I'm going to give you some pleadings anyway. And they issue those as a matter of course to everybody who falls into that position. And you can see that then they also develop the law. They are also saying every time that situation occurs, you can come to me and get a pleading so that you can go to court. And that also develops law in a very interesting way that we don't really have a parallel for in our system. And then the final source is development by named jurists, these legal writers I talked about before. These writers, by their writings, by their arguments between themselves, develop the law, and they do it in a similar way to case law in our system. The way that the jurists work, they reason on as to what they think the law should be. They say, given that this situation will be resolved in this way, I think that this other situation should also be resolved in that way. Or they say, no, actually, when I think about this other case, that's relevantly different. I don't think that should be treated in the same way. So, for example, the jurists were considering when is it theft for one person to take or lay hands on or interfere with someone else's thing? It would certainly be theft if someone simply picked up another's book and ran away with it. But what if they are merely approaching the bookcase and with their eyes intent on the book and they're interrupted? What if they are lent the book and then they simply decide to keep it? Do any of those constitute theft? These are the sorts of things that the jurists are dealing with. And they hammer out the law in this way by incrementally developing it. So they do it a lot by discussion between themselves. So one jurist will say, well, I think this case should be resolved in this way. And another jurist will say, well, no, I disagree because of this reason. And then they will argue between themselves. And what they end up doing by all this argument and writing is pushing the law forward incrementally. Over time, some common ground develops and everyone agrees that a certain part of the law should be resolved in a certain way. Or sometimes they split. They come to have very different views on a particular issue and they cannot agree. And in those cases, we do know quite a lot of instances where there were celebrated disagreements between the jurists, some of which were only finally settled at a point when Justinian gave legislation on it, at the time when he was developing his law library. So the role that the jurists had in Roman law, they do give advice to litigants about what cases they can and cannot bring. They give advice to judges who are trying to decide cases, as I referred to before. They give advice to the official who makes the rules about the claims in court as to what rules he should and shouldn't allow for pleadings. They do all of this writing and arguing that I've talked about. They are responsible for interpreting the words in statutes. So if a statute says if something has been stolen, then they need to work out what that might be, what that might mean. For example, they might say, well, what does it mean to say that something has been sold? We're going to talk about that in a moment. So they need to work out what is the definition of a contract to sell, what is the definition of theft, what are the definitions of various words that are used. They develop the law outside the statutes, and I bring you some examples of that as well. Their role does change over time. They tend to be more they tend to have a more dramatic effect on the law earlier on. And as time goes on towards the middle of the 3rd century, it tends to be more and more arguing about technical issues, narrowing the law down, looking at definitions. So they're not making broad sweeping interpretations anymore. They are tending to work out what definitions are and to differentiate between cases in quite a sophisticated way on perhaps more technical grounds and differences. After the middle of the 3rd century AD, the last of the named jurists dies, and when the dominate arrives, we do not have named jurists anymore. It's not that the role of interpreting and understanding the law didn't need to be done anymore, but that role went into the emperor's civil service. And it is at the start of the dominate that we see the emperor take over everything about the law. The emperor is now the only legislator. The emperor's civil service is the only one that interprets the law and advises on how it should apply. The emperor, and this is all done in the emperor's name, so his civil service will answer questions that are given to him and will advise him on what legislation should be made. And the idea of having flexibility about what claims are allowed in court has been out of the Roman system since about the mid-2nd century AD. Now I'm going to give you some examples about how the jurists worked and the effect that they had on the law. So the first example that I have for you is on a particular Roman wrong, which was the wrongful infliction of loss. And this is particularly interesting because there was a statute which the Roman lawyers had to construe, which this delict of the wrongful infliction of loss was based on. And that statute was called the Lex Aquilia. It was passed in about 287 BC, By the time of Gaius's institutes in 161 AD, this is what Gaius tells us that the wrong covers. He says it covers the wrongful killing of another slave or cattle and other economic loss that is wrongfully caused by wounding a slave or cattle, by damaging other things. They may be animate or inanimate, so damaging, for example, a dog or a cat, or an inanimate object like a book or a vase, and in some cases by other means without damaging property. So, for example, let's suppose that I come down from the city for the day and I see some cattle standing in a field, and I think it would be so much fun if I ran into the cattle waving a red flag and trying to scatter them. And the cattle do startle, they run, they jump the fence and they run away and they are never seen again. In that case, the owner of the cattle will suffer an economic loss, but it won't be by the killing of the cattle or any kind of physical damage to them, but they have been lost, and therefore there has been economic loss. And what you can see about this statute, as it's understood in 161, is that it covers economic loss that is caused wrongfully by some sort of interference with property, typically by physically damaging it, but in some other cases without damage, a loss may be caused. It was differentiated from theft. So obviously theft also involves me having an economic loss because I don't have my property anymore, but the Romans dealt with that under a specific wrong of theft. So they had theft on the one hand, that attracted a penalty, and they also had this wrongful infliction of economic loss by other interference with property, and that attracted compensation. But this is Gaius's account of the Lex Aquilia in 161. And what we need to do is go back to 287 and see if we can work out what sort of wording the statute had and how it developed. So this is my best effort at reconstructing the Lex Aquilia in 287 BC. So it had 3 chapters, but I've taken out chapter 2 because it's not relevant to what we're talking about. So first of all, we have chapter 1, which says if a person has wrongfully killed another slave or cattle, he must pay its highest market value in the previous year. And if he causes other loss by wrongfully burning, breaking, or smashing anything, he must pay whatever the matter turns out to be worth in the nearest 30 days. And what I'm going to look at is 3 of the issues about what the statute said and how it's interpreted. But every time I look at this statute with a tutorial group or in a seminar or on an open day, students raise new issues. So if you see something there that you think is interesting that I don't talk about, then you're almost certainly right. What I will say first, before I go into what the jurists do, is if you look at this, you'll notice that it's not set up in the way you might expect if you've done some English law. So sometimes people say to me, well, how does this law fit into ideas of the guilty mind and the guilty act in English law if they've looked at some criminal law before? Or they say to me, well, where's the concept of the duty of care from English tort law? And I think these are really good questions because it starts to show us how Roman law can challenge us in our ideas about how law is made and what its patterns of thought are, what patterns of analysis we should fall into with it. Because neither of those things maps onto what the Lex Aquilia actually said. What it said was, has this person wrongfully killed? It doesn't say, what's their mental element, what's the physical element. It just says, have you wrongfully killed? Have you wrongfully burned, broken, or smashed? It doesn't talk in terms of duty of care. And I think this is good advice for if you're thinking about interviews and the sort of scenarios you might have there, is that when we start with something new, we should try and understand it on its own terms first. And then we should try to say, how is that challenging ideas that I've got from English law? But let's start from looking at the Roman provisions first. So there were a couple of things the jurists needed to look at. One of the things they had to look at was, what does it mean to kill? So, for example, what if I have tempted a cow to walk over unstable ground and it falls over and it breaks its leg? Have I, in that case, broken? Or if it dies from that accident, have I killed? And the jurists eventually decided that to kill or to burn, break, or smash was to directly apply force to the thing. So a strangling or a stabbing would be examples of things that do fit within kill or break, but to create a situation that was dangerous and that ended up with the thing becoming injured, or that was a fatal accident to it, that was not, they said, killing or breaking. And they actually had to go to the official who issued the claims and say, we think there should be a claim as well for cases where a person has provided a cause of death to property, rather than a situation where they have killed. And the same with burning, breaking, or smashing. So let's suppose a case where I light a bonfire and I don't watch it properly, and the fire runs out of control and burns your corn. In that case, I did not directly burn the corn. I didn't strike a match and hold it to your field, but I did allow it to run out of control. So that was one thing that the jurists had to deal with. Another point that they obviously had to deal with was the idea of when it would be that I had wrongfully killed. So was it a case, would it be any case where I couldn't say that I was justified? So for example, if we think about killing, would I only be justified in killing if I did it in self-defense or in some way that I couldn't escape a danger? But that's very narrow. That means that I'll be liable in any case where I kill or break or burn or smash, and I don't have a particular reason for doing it. So the jurists thought about this, and in particular, they thought about the case where I kill by accident or I break by accident. I could not help it, I say. It's not that I didn't, it's not that I have a justification. It wasn't self-defense. It was just that I could not help this thing happening. And the jurists thought about this for a long time, and eventually they came up with the idea that I should be liable if I was at fault. So, for example, if I am a soldier and I practice my javelin throwing in a place where it is usual for soldiers to practice, the jurists tell us that I will not be liable if I throw a javelin and it goes into a horse, let's say, that's running across the practice ground. It's not my fault that I didn't look around before I threw. However, if I do see the horse approaching, I must not create danger to it because I then know it's there. There's another example of somebody who prunes their tree. If they prune their tree that is next to a public highway, then they must call out before they drop the branches because they might injure someone or something passing below. However, if they are pruning their tree that is in the middle of a field and away from everywhere, then they don't have to call out before they drop the branches. They are entitled to assume that there is nobody passing below, although if they do see somebody again, they must be careful. All of this comes to a situation that is quite similar to the English law of negligence, because the idea of what should you foresee, what should the careful man foresee, it does have some parallels with the English law of negligence, but it's not exactly the same, because the Romans always come back to the issue of who is at fault in this scenario. Whose fault is it that there was killing, that there was burning or breaking or smashing? And then finally, another thing I wanted to talk about here was this idea of paying the highest market value. So the jurists had to work out what that was. Highest market value for chapter 1 and whatever the matter turns out to be worth in chapter 3. And the jurists said to themselves, is that just market value? Is that just what you would have got for the horse, let's say, if you had taken it to market at the time? Are we looking just at the market value? And they decided no. They said you are actually looking at compensation more for the loss. So if, for example, you had 2 horses and together as a pair, they were worth 300, but each of them singly was worth 100. If one of them is killed, the loss to you is 200. And the jurists eventually said, yes, you can claim that, even though it goes beyond the market value of the one horse that was killed. You can actually claim the whole loss to yourself on the basis that you did have a pair and now you've lost 200 as the value of the pair from the one horse being killed. So those are examples of the way that the jurists work on interpreting the statute. And now I wanted to give you some ideas about how the jurists worked when they didn't have a statute to go on. They were just developing the law from what they thought were logical principles. So one of the points that the jurists had to determine was, what is a contract of sale? And this was important because if you think about a time when you might contract to buy something, you might have a problem with that contract of sale. You might not get what you were promised under the contract, or you might get something that is not the quality that you thought it was going to be. So you go to the official who issues the claims and you say, I want to bring an action against the seller. They didn't provide me with the thing I thought I was going to get under the contract, or it wasn't of the right quality. I contracted with them to buy feed for my chickens, and actually the feed that they sold me was defective. It made my chickens sick and I want to sue them. So the official gave an action that was to say, if you have a contract of sale with somebody, then you are entitled to whatever it is fair and decent for them to provide under that contract. Well, that's all very well, but then you need to know what a contract of sale is. So the jurists debated. They said, is that a contract to exchange goods for money? Or does it also include a contract to exchange goods for any other thing? So, for example, if I say, well, I will give you a cloak or a book or a piece of land to acquire this thing that I want from the seller. It mattered because under the contract of sale, the buyer and the seller have different duties. And so eventually the jurist said, actually, what we do need to do is to differentiate between those two people. And therefore, we're going to narrow down a contract of sale to just a contract to exchange goods for money, because otherwise we won't know who has the duties of the buyer and who has the duty of the seller. Here's another example of development from first principles, and it was in property law, the question being, who owns wild animals? Is it possible to own a wild animal? If so, when? The jurist said, while a wild animal is free, nobody owns it. If you catch a wild animal, you do own the animal while you possess it. However, if you lose control of it, then you don't own it anymore. The ownership is lost at the moment when it is out of sight or too difficult to pursue. How do you know whether an animal is wild or tame? It's about the nature of the animal. So, for example, a tiger will always be wild. Then they had to deal with a further issue for animals which habitually return. So, for example, bees. Bees were incredibly important in Roman times because they created honey, and honey was the preservative that was used mainly for food. So bees were an incredibly lucrative animal to have around, and obviously bees do habitually come and return to their hive and go out again. So it was very important to know when you would own your bees. And the answer that was come to was that while they were in the habit of returning to the hive, they were still owned by the person who had the hive. But that if they swarmed, so a new queen arises, a swarm gathers, and the bees gather in a swarm and fly away, at that point, you will lose ownership if you do not pursue the swarm. Someone else might be able to catch it and hive it. Here's another example of development by the jurists, and it's this question which seems very simple, and it is this: if A makes wine from B's grapes, then who owns the wine? And there are two possible answers. Let's suppose A and B haven't agreed on this. Let's make it properly difficult and say to ourselves, okay, one possible answer is that A owns the wine. Another possible answer is that B owns the wine. Now, anyone who's willing to go for one of those answers and say why, please do type in the chat as to which answer you think is the best one and why, because that would be great for me to see what you think about that. I'm just going to look at the questions in the chat while you're thinking about that. yeah, this is very similar to the lecture that was given, but obviously we were able to put hands up to get an idea of what people thought about this one. Okay, so one possible answer that someone's put forward is, do they have joint ownership? That actually was something that the jurists never came up with. They said everybody split on, was it one or was it the other? They didn't say we could have joint ownership between both A and B, although I could definitely see why you might say that. Some people have said, is it about the previous interaction between them? That could definitely be relevant to whether somebody gets compensation afterwards. So if we were to say that A owns the wine because they made it, then we might say, well, how is B going to get compensation? And one person in the chat has suggested that there might be a contract of sale. So let's suppose that B has sold the grapes to A. They said, until you pay me, I'm not going to let ownership transfer to you. A makes the wine, A owns the wine, but A still has to pay B under the contract. So yes, that does make it add up. If we say, what were the circumstances between A and B before? Someone has very sensibly said, one argument for person B owning the wine is that person A could have made wine with any grapes, but person A has made the wine with B's grapes, and that makes a difference. So without the grapes, the wine wouldn't exist. And that's been agreed with by quite a lot of people, that they have provided the raw materials. If somebody doesn't have permission to interfere with your grapes, then they should still have ownership of the wine, because that's where their grapes are now. However, people who look at version A, we have people who've said A has taken the process and time to make the wine, so they have put in their labor and they have created something new. And somebody has said, well, what about the point about wild animals? So given that a wild animal isn't owned beforehand, and when the person takes possession of it, they can own it, can we make that to be a similar issue for this wine? Because the wine came into existence and A was the person who made it come into existence. So that is the opposite of the idea that the grapes are the substance in the wine, to see the wine as an entirely new thing. And that actually is probably the reason why the Romans did come to answer one, because of a particularly Roman perspective. So the Romans say, somebody is going to be making a claim to this wine. Well, if B, who owned the grapes, comes along and says, that wine belongs to me, then the obvious answer to that is to say, well, you only owned grapes. How can you now say that you own wine? That was a new thing that was made by A. You never owned any wine, so you can't say that that wine belongs to you. So probably the Roman answer, probably the first answer for the Romans, was A owns the wine. A later rationalization of that is because A made the wine and they therefore put their labor in. But a later answer is probably answer 2, because B owned the grapes that went into the wine, and it's only fair that B should continue to own the wine because the substance is in there. What are the answers actually given by the jurists? Well, Gaius in 161 is probably saying, although his text isn't very clear, that A owns the wine, but Gaius thinks that's wrong and B should own it. Justinian, who is a legislator in 533 and therefore is able to settle this matter, does so. He says A owns the wine. However, if A were to make a statue from B's gold, then B owns the statue. So he makes a distinction between those two cases on the basis of reducibility. He says the wine belongs to A because A made it and the thing is not reducible to its raw materials. However, he says, if the statue is reducible to the lump of gold, then B owns the statue, whether or not it is actually reduced. Now, that is a distinction he could draw because he was a legislator and he could put in place any kind of law that he wanted. But one of the things people say to me is, well, does that make sense? Does it make sense that we're distinguishing between a marble statue and a gold statue just because the marble cannot be reduced, but the gold can be? And that is certainly a debate that we could have in a tutorial, but it does show you the difference between what the jurists do. They try to reason things out. Is it right to say the substance of the grapes is in the wine, or is it right to say the wine is a new thing? Whereas Justinian can say, these are the results I think are fair, and I'm going to draw the distinctions I think are fair, and I do not have to have logic behind me necessarily. And that was something that a legislator can do that a jurist can't. But whether it makes sense is another matter. And I think what this example really shows us is the fundamental best question that we can ever ask about a legal matter, which is, what is the difference? And why does that difference matter? Or why doesn't it matter? So Justinian obviously thought that the difference between something that was reducible and irreducible should matter. But whether he was right or not is something that we can certainly debate. I want to tell you a little bit about what happened to the jurist writings in later Roman law. So in the Dominate, we know that the individual named jurists died out and their work carried on, but it carried on as part of the anonymous emperor's civil service. And their work survived, but the Romans found it increasingly difficult to cope with the massive juristic writing they had left behind. So remember that the Romans didn't have any of the tools that we have for organizing a massive writing and accessing the information in it. So they didn't have computers or AI tools or anything like that to help them organize a massive information. The best upgrade that the Romans had by the time of Justinian to deal with a massive writing was a bound book, which is a huge technological upgrade on the previous version of the scroll. If you think about going into a library full of scrolls and trying to read and understand and categorize all of the information on it, it makes you glad even for the technological upgrade of the bound book. And a computer is an improvement beyond the Romans' wildest dreams. The Romans had that problem with this massive writing that was difficult to reconcile, and they also had difficulty because the standard of legal education had dropped. So it was less easy for people to get into a position where they felt confident that they would be able to work their way through all of this argument and reasoning. So one of the things that the Romans did to try to deal with this problem is a statute called the Law of Citations from 426, which is probably my favorite piece of legislation in the whole history. And basically this was a way of trying to work out what the right answer was according to times when jurists had different views on it. So they identified 5 jurists, and anytime you had a problem where you thought the solution would be in the jurist's writings, you looked at what each of those named jurists said on the matter and you counted. So you looked at how many of them said that the answer to your question was yes, and how many of them said that the answer to your question was no, and then you looked at how many were on each side. If you had a tie, then one of the jurists was named as having the casting vote. So I love the Law of Citations because you can see the problem. It gives you a very great insight into the problem. And the problem is they don't know how to work out what the best answer is on the basis of the writings that they have. And we can all recognize that problem. It's a very difficult problem. It starts with the issue of what is the best answer? What are our parameters for a good legal answer to a question? This is why it's so often said in relation to university studies that there is no right answer. It's why it's an obvious issue in interviews is that people ask me at the end of the interview, well, what was the answer to the question? I say, I don't know. It was about us trying to work out what a good answer was. But the law of citations shows you that the worst way to try to answer that question is to say, what do famous authors say about it, and how many of them thought yes and how many of them thought no? That's not the way to reach a good answer or the best answer. The only way that we're going to do that is to work out what we mean by best and what we want out of the law, and to reason to a good answer. So Justinian decided he had a new approach. What he wanted to do was to bring together the writings of the jurists, compress them so that they fitted into one book, and make them state the law of his own time. So removing all traces of debate between the jurists, and removing the obsolete law that didn't represent the law of his own time. He was going to make one book of it all and put it into his codification. The real problem with that was that he got rid of a lot of material. So sometimes modern commentators will talk about Justinian as a sort of legal vandal who went through all of these classical legal writings and stripped out so much material. And you can say that, but the thing about the codification is it did preserve a lot of the classical writings. It's given us a lot to study, and probably if Justinian had not compressed it together into one book, the probability is that very little of it would have survived at all. So he did at least give us something to look at. So when Justinian commissioned the digest, he had the classical legal writings read and excerpted and made into a sort of scrapbook. So it still says the jurist who said a particular thing and a paragraph from them, and then the next jurist saying something slightly different on the topic will be preserved underneath it. But the people who made the digest went in and edited it. So they stripped out the material they thought wasn't necessary, and they would edit it directly to take out debates and settle them in the way Justinian said they were to be settled, update it to the current law, and so on. So to reflect legislation that had been made since then and by Justinian himself, and also just to introduce a settlement of debates and to make it read more smoothly for the contemporary law. When we read the digest, it does read like a scrapbook. It reads like a lot of almost disjointed statements from different jurists. It is as though you went into a library and you decided you were going to put together a scrapbook for yourself of all the law on a particular topic. That's what it's like to read the digest. But even though the digest is such an unusual book, it did provide a lot of material for what's called the second life of Roman law. So the second life of Roman law is Roman law in modern times. It's the influence that Roman law had on the French civil code, the German civil code, law across Europe, and also in this jurisdiction. Jurisdictions would dip into this treasury to find the law that would be best for them, to work out what solutions had been worked through in the centuries of Roman law's development, and benefit from all that learning. They didn't have to copy it exactly, but they could benefit from what the Romans had hammered out beforehand and see what those centuries of legal development had led to. So to finish off the law library, we have the digest, which is the edited classical writings. We have the institutes, which is the textbook I talked about before, the second edition of Gaius. And we also have a statute book, a collection of laws declared by the emperors, which is called the Codex. And I'll put just Gaius's institutes alongside it so that you can see the two institutes that we study. So the second life of Roman law, this treasury of Roman law that people dip into, leads to a distinction between common law and civil law jurisdictions, if you've heard of that distinction. England and Wales is known as a common law jurisdiction because it was very early, comparatively, that England and Wales had one law that covered the whole jurisdiction. Civil law jurisdictions are known as such because they have a more direct inheritance from Roman law. However, if you look into English law, it doesn't take you long before you realise that English law owes more to Roman law than it admits on the surface, because it's sensible. It's only sensible for a jurisdiction that's developing its own law to look sideways, look at the Roman law, look at what's been hammered out and say, we will have the best of that. We will adapt it for our conditions, but we will also take what the Roman lawyers have worked out. The fact that Roman law is the basis for so many civil law jurisdictions makes it easier to engage in comparative law studies if you have a Roman law background. So one of the things that studying Roman law in the first year at Oxford gives you is a basis for that comparative law study, because you'll always know roughly where you are if you start in studying the law of another jurisdiction, which has some sort of Roman law inheritance. And the other reason I think that Roman law is so useful is because one of Gaius's prevailing juristic concerns was to learn and think about the law in a good way, and in particular to organise the subject clearly, because Roman law began from a sort of heap of actions. And so one of the things Gaius did was to work out how law could be structured and how we could start to think about it and to work out important things such as what distinctions matter and why. And as I said before, I think this is the fundamental, most important question that we can ever ask as a lawyer, at whatever stage of our legal journey we may be in. What distinctions matter between two scenarios, and can we explain why we think they matter? I noticed somebody said earlier on that they would like some further reading ideas, and so I'm glad I produced a slide for them. So there you go. There's also a very beautiful picture of my college because I wanted to make the slide prettier. I will look at the questions in the chat now. People have been asking, I think a few people have been asking about whether there is something more theoretical about Oxford's degree than other degrees. I don't think the Oxford course is necessarily very theoretically based, but we do make the study of jurisprudence compulsory, which is sort of legal philosophy. So that may be one place where you might get that impression. But I think all law is necessarily theoretical, because unless you think about the theory, you're not really going to be happy about understanding why the law is coming out with the practical consequences that it is. So I think all advanced law courses are theoretical to some extent. Focusing on all types of law or only one type, the Oxford Law course includes a lot of modules that go across both private and public law. So if you look on the website, you can see which modules are compulsory and also the range of options that you can choose from in your final year. So you do get 2 options choices as well. So people have asked me about extracurriculars and supercurricular activities. So there are no particular extracurriculars or supercurriculars that we look for when we're assessing your application. I think it would be wrong for us to be looking for anything in particular, because people have different opportunities for what they're going to engage in. So my advice to you would be to go ahead and do whatever it is that you feel would help you to understand better your potential as a law student and to investigate whether law is the right degree for you. So for some people, that might be about getting some experience in observing court cases and seeing how barristers put their arguments together. Some people might be able to get some work experience shadowing in a law office and see how the law is dealt with in sort of practical ways as well. Other people prefer to read up in books and or to pursue looking at real life cases that you can follow. So, for example, if you see a big case that's been decided in the Supreme Court or the Court of Appeal, you might decide to follow up on that some. It's really not a problem for me what you have engaged in. What I'm looking for in your application is about how well your application is demonstrating strength in the application criteria that I'm looking at. You cannot apply to both Oxford and Cambridge, I'm afraid. Someone has asked about the characteristics of the ideal candidate. So I think this is a really good opportunity to talk about the selection criteria. So if you look on the website, you will see what the selection criteria for the undergraduate degree are. And Emma, you can correct me if I get this wrong, but they are application, communication and reasoning. So those are the strengths that we're looking for, and people demonstrate these strengths in different ways. But if you look at those criteria and think about, well, what do I do that helps me to demonstrate strength in those areas? And that's a very good place to start with putting together a personal statement and what you want to focus on. One thing I will say is that the Oxford Law course is really somewhere people who really love reading and writing will flourish. So that is what you're going to spend a lot of your time doing, because it's quite heavy workload. You have typically to be doing 3 essays per fortnight, and for each essay you need to be on top of the material and to be ready to talk about those issues in your tutorial. So you'll also be having 3 tutorials a fortnight. One thing I will say, if you're thinking about communication, is you absolutely do not have to be a confident public speaker. People sometimes say to me, oh, I can't possibly apply because I don't really like doing public speaking. And you really don't need to be to have anything more in mind than just sitting down with 2 or 3 other people in a tutorial once a week and talking about what you've read in the materials for that week. And that's just an ordinary conversation. A tutorial discussion is just a chance for you to ask questions and me to challenge you with questions and arguments, and for us to work out together what we think good answers are. So you definitely don't have to have any strength in public speaking to be good at that. It's been so much fun to talk to everyone today. Thanks ever so much for inviting me along. Take care, everyone.
Amazing. So the sponsors of the event today are Clifford Chance, and they have very kindly donated some of their time to come and speak to you guys and ask all the questions that you want. Use the Q&A, you can use the chat, you can use reactions. So I will welcome, we've got quite a few people actually. We've got Rachel Plume, Dom, Chimdi and Lena.
Hello everyone. Yes, as Emma kindly said, my name's Dom, and I'm from Clifford Chance, which is the law firm that sponsors these events. So we did a couple of in-person ones yesterday, the day before, and obviously this online one as well. And I'm here to talk. We're here to talk a little bit about life as a lawyer, introduce you a little bit to our firm, and explain some of the opportunities that we've got going on as well. So I work for the firm. I've been working for the firm for about 5 years. Lena and Chimdi, who we also have on, will soon work for the firm. So they've got like offers to come and work as solicitors. And to be honest, I think I'll let them do most of the talking, as I'm quite conscious that they're just closer in terms of experience and age to you guys as well. But I think the key thing to say is, we're a firm of solicitors, and it's good to go into, potentially studying the law with your eyes open as to the difference between a solicitor and a barrister. A barrister does the arguing in court. A solicitor is maybe the broader role, but does paperwork, contracts, negotiations, those kinds of things, and doesn't sort of stand up in court and make arguments. So I'll just tell you a little bit about Clifford Chance. We're a really big international law firm. So we've got, I think, 30 offices in 22 different countries. And we're headquartered in London, long history in London, but yeah, very international. And so should you down the line sort of come and work with us, then we've got lots of opportunities for international secondments to our offices, and that's a really good perk of working for such a big company. I guess more relevant to you guys is that we are a very prominent sort of employer in law. We recruit about 100 people a year. And I think crucially for you, we're not saying come back and see us in 3 years' time when you think you want to sort of be a lawyer and get a job in law. There's stuff that we have that you guys can engage with right now. So I think Lena and Chimdi will talk a little bit more about that, or I can if we don't manage to cover that. As for me, just super quick, 1 minute. I went to state school in Reading. I did French, English, maths, and history as A levels. And I didn't do a law degree, so I did a history degree. And if there's one thing that I would say to you guys, it's if you're thinking about studying law, I would really recommend taking the time to figure out whether that's because you're interested in it or whether that's because you think you want to be a lawyer. If you think you want to be a lawyer, that's fantastic. It's a really good profession. But it's practicing law is quite different from studying law. And it's very possible to sort of convert as I'm sure many of you are aware, convert your non-legal degree into a legal degree. And so, yeah, I'd encourage you to explore the materials that you can get your hands on, read some cases, go to the courts, see something argued, read maybe a legal textbook, that kind of thing, because 3 years is a long time to study something that you're kind of, oh, well, I'm doing this for my career. And actually, there's not much point because, frankly, you can be a lawyer without doing a law degree. So the law is a fascinating thing, but if it doesn't grab you, that doesn't mean the law is not right for you, but it might mean that you're better off studying history or music or engineering or anything really. So that would be my sort of one takeaway. Lena, maybe you'd like to introduce yourself and.
Yes, of course. Hi. Hello, everyone. My name's Lena. I am a future trainee. I went through the direct training contract route just in January this year, so very much new. I was exactly in your shoes 6 years ago. I attended an event like this at Oxford, and I ended up studying jurisprudence, but I did the course too, so I had a year abroad in France in my third year. I actually wanted to study law without really knowing, or I didn't really have a dream that I was going to become a lawyer. I was just interested in law because I thought it was such a huge discipline that encompassed so many different things, and I thought that would be a great way to kind of go into university and my undergraduate education. My A levels were quite split. So I did maths, physics, history, and French. So clearly, as you can see from that, I really wasn't sure what I was going to apply for. I think in the end, I was choosing between physics and law, but then realized I didn't like practicals very much. So law made a lot more sense because it's very logical. I like the philosophical element, the anthropological element. And so that's why I really wanted to just study it as an academic discipline. Then throughout my undergraduate degree, I kind of explored different areas of law. So for my modules, I did medical law and family law, which is nothing at all like what a corporate law firm like Clifford does. But I was just curious about everything. And in the end, I realized that I was better suited for corporate law, because contract law I was very good at and I really liked tort law, things like that. So it just made sense. And I think the moral of that is you don't have to have your mindset about what you want to do. If you do, that's fantastic. If you don't, like me, it doesn't really matter. Yeah, I chose Clifford Chance because, again, 6 years ago, that was my first contact with a law firm. I hadn't really heard of any other law firms, and I think it kind of stuck with me throughout. And it's full of really great people and really great clients. So the works will be interesting, which wasn't available in my time, but is available for you guys, which is really good. You have a couple of virtual internships called Ready Steady Law, and that will just kind of give you a taster as to what a firm like Clifford Chance does, just so you can kind of explore your options and see what you like. And if you have any further questions, I think we'll do a Q&A at the end of this. And then I think for a discussion about a different path, I will hand you over to Chimdi.
Yeah, thank you, Nina. Yeah, hi guys, my name's Chimdi. I studied theology and religion at Oxford, so took a different path to Nina, the non-law route, similar to Dom. And I'm currently doing what Dom described in terms of converting a non-law degree to, I guess, it's called a qualifying law degree, which essentially means that you can then build your professional qualification on top, because whether you do law or non-law, everybody has to go through the professional qualifications, which are now called the solicitors qualifying exams if you're going down the solicitor route, which you would do if you're coming to amazing firm like Clifford Chance. So that's what I'm currently doing now. I guess for me, funny enough, actually, first time around applying to university, I've always known that I've really really wanted to pursue law as a career, and thought because of that, I had to study law at undergrad. So I actually applied to do law at undergrad, and it didn't work out because I realized, kind of like Dom said, in terms of the spending the 3 years of like going through textbooks, case law, and all these different things actually wasn't as interesting to me as other things, which for me ended up being like theology, sociology, and that cultural elements. So that's why I ended up then reapplying and actually studying what I was passionate about. And I'd say definitely for an institution like Oxford, if you are considering applying, which I hope you are, since you're all here on the call today, I would definitely say prioritize something you're passionate about when it comes to your undergrad, because ultimately university is very different to sixth form study. You haven't got period 1 to 5, and there isn't people forcing you to be there. It's very independent, and you have to be driven in your studies, more so especially at Oxford. So that for me, I'm glad I made that route, and I'm still where I want to be in terms of pursuing a law career, even though I didn't study law at undergrad. So hopefully that's encouraging as well if you're a bit on the fence in terms of what you want to explore. To make a note that you don't need to study academic law in order to pursue a career in law. But that's me in a nutshell, I guess. So back over to you, Dom.
Great, thank you so much, Chimdi. I see we've got a couple of questions coming in on the chat. I think just in terms of other points that I think when previously we've run these sessions, people have found useful is that, number one, Oxford is a wonderful place. However, it's not the be all and end all. You can get an excellent education, legal education or non-legal, at many, many other universities. And some of my best friends, some of the best lawyers I know, went to the universities of, to name a few, Edinburgh, Warwick, Bristol, UCL. The list kind of goes on, and I think it's really easy to build it up in your head and think, oh, everyone around me is doing this. But I'd encourage you to, retain a sense of perspective, because I know it can be really tricky. Secondly, I think the best way that you can sort of, in terms of applying for a job like the one that we're describing, I think it's really good to talk to as many people as you can. I mean, I didn't have lawyers in my family. I didn't know any lawyers really. And so it was really helpful to me to sort of engage with the firm at various, events, a bit like this. When you get to uni, there'll be plenty of events like this. and you can do these sort of internships, and that gives you a chance to, and the access scheme, which gives you a chance to talk to people and figure out, can I actually see myself doing this? Are these people that I'd, like to surround myself with? Those kinds of questions. So I can see we've got a couple of questions coming in. First off, if you're not entirely sure whether you want to become a lawyer, do you think a law degree is a good course to keep your options open? Lena, I wonder if you're best placed to answer that.
Yeah, so yeah, I would agree. So learning law at undergraduate does give you very useful skills that other professions and other industries really appreciate. So a couple of my friends have gone down the more finance route. So they do private equity at Goldman Sachs. I have friends who became consultants. I also have one friend who is becoming a doctor as well. So he's putting himself through medical school, which is a very long route, but it's available to you. And yeah, so really it gives you a very good basis, I feel. Like Dom said, the practice of law and what you learn at undergraduate, whilst there is obviously similarities between the two, they are different. And whether you actually want to become a lawyer or something else, I don't think studying law as an undergraduate would restrict you. You're learning those skills of analysis, of debate within writing. That kind of cognitive way of thinking is useful in other disciplines if you decide being a solicitor or barrister isn't for you.
Yeah, and I think to answer another one of the questions that's come through in the chat, the reverse is also true. The skills that you learn in a history degree, a theology degree, the ability to analyze, the ability to condense and sort of summarize large amounts of information, the ability to look at things from different arguments is really useful when practicing the law. Another question I think is, does it take slightly longer to do a non-law degree and convert? Yes, that is the case. You have to do a sort of 1 year conversion course. What work experiences did you guys do to further your application? Maybe Chimdi, you'd like to talk about that?
Yeah, sure. So, what did I do? So I looked around at a few. So in year 12, at this stage, I think it was just focusing on attending different open days that different firms offer. At that stage, I was also considering the bar route as well. So also if there's any programs that spoke about that, just getting more information. I think with these work experiences is less so about the names, but more so what you've gained from the experience and what you've learned. So that was my priority. And then in first year university, I applied for Spark, which is one of Clifford Chance's programs that they run. And that was amazing in order to get insights into different departments and what people do, because you hear corporate law and you think, oh yeah, you're just working with businesses all day, which is part and parcel of what Clifford Chance does, but there's so much more to that, and there's so many different departments within the firm. So I did those kind of similar things with Clifford Chance, but also other firms within my first year, as well as keeping my options open and apply to a few things in consulting as well, just to get a wide idea of what I wanted to do, and found that I loved law and loved Clifford Chance. So that was the route I ended up pursuing in the end.
Thank you. For my part, I think when thinking about applying to, I obviously didn't apply for law, but when I applied to Clifford Chance, I think all I had on my CV was Waitrose. So I think I'd really encourage you to think about what you've done and make it work for you. If you're doing what you sort of enjoy, whether that be extracurricular, whether it be, a part-time job, whatever you've got, think about how that means that you would be good at what you're trying to sort of apply for, I think is a general piece of advice. Just having a look about what does the LNAT involve and what are its minimum scores and how do you prepare for it? I think, Lena, you would be the only person who'd done the LNAT among us, so
yeah, it's been a while, but unless something has changed, I don't think there are minimum scores per se. So for example, I never actually found out what I got in my LNAT, because it gets sent straight to the universities you apply to. And I wasn't one who was particularly excited about multiple choice, and I really was relying on the essay portion of it. So I think everyone's different. Everyone's going to have different strengths, whether that's you're better at multiple choice or you're better at the essay philosophical question at the end. But I think if you practice, I practiced over the summer just before your LNAT, and also remember to book in for the LNAT, because if you want to apply for Oxford Law, there are specific dates you need to meet for that. And some testing centres fill up. So just make sure you're on that. And yes, I'd say do some past paper practice, but I didn't really have any formal help with that. I think I bought a book of past papers and I just kind of worked my way through that in the summer. Yeah, I mean, it's been a very long time, and
No, that's great. That's really helpful.
Yeah. I mean, I've had a couple of questions about corporate
Yes, of
law,
course. Yeah, please
which
do.
I think might be a good idea just to quickly run through. If you're interested in applying to someone like Clifford Chance, it's a good idea to know kind of what corporate law entails and what you would be doing if you were to work for Clifford Chance. So corporate law in a nutshell, I think it's in the name. You're working for corporations, and that doesn't just mean you're working for a bank or something like that. It's so broad, and I think that's really what attracted me to it. So litigating over, I don't know, an oil gas leak, or you could be working on the financing of a building that you're walking past. It's so broad, and you have different types of seats. So you have transactional, where it's more on the deal side. So if two companies want to perhaps acquire another company, or any other thing like that, that's kind of more on the transactional side. So you'll hear people who work in banking law or private equity law. That's kind of what they're doing. And you have more kind of research-based departments. So you're working on the regulatory side of things. So it's very, very broad, and as you can see, a little bit difficult to condense in a couple of sentences. But there are
CC's like big strapline is to be the leading advisor to the leading global advisor to the leading businesses of today and tomorrow. So I guess that kind of plays into that, doesn't it? In terms of it's basically the top businesses, and we're looking to be their one-stop shop.
Exactly.
Do you think is that sort of fair?
Yeah, and so from that you cover so much, and you can get involved in so many important things, because at the end of the day, capital is what drives progress. So if you're the lawyers to the corporations who do that, you are involved, and I think that's what drew me to it. But yeah, I think on the Clifford Chance websites, especially if you go into the news section, you can see kind of all the deals that are being done, and that's a good starting place if you're interested.
Absolutely. I think there's also an app called Forage, on which we have a little course that you can attend.
I think it's the Ready Set Law one.
Ready Set Law, that's right.
Yeah.
All the best to all of you, and yeah, it's been a real pleasure talking to you, and hopefully someday we'll see you sort of walking through the doors of our building. And yeah, all the best with your uni applications and everything else.
Thank you so much for joining us today. It's been really, really informative.
Thank you.
Okay, next up then, and lastly on our list of things to do today, is our ambassadors. Our student ambassadors are coming up. Okay, so we've got a few student ambassadors that are going to come and answer your questions. There's quite a few questions already in the Q&A that they would probably be the best people to answer it.
All right, I'll go first. Hi, I'm Iman. I'm a second-year law student, and I'm at Hertford College. And I kind of introduced by talking about the A-levels I did. So I did politics, psychology, Spanish and English literature.
I'll go next. Hi, I'm Jess. I'm a second-year law student as well at New College. And I did history, English literature and maths at A-level.
Hi, I'm Afsa. I'm also a second year law student. I'm at Mansfield College and I did history, RS, chemistry, and math for A level.
I got 4A stars, but I do want to preference that they don't, just because you don't get 4A stars doesn't mean that you're completely off the list. I mean, a lot of people that I know did get Bs, and there were some who did manage to like still get that offer. So they are quite flexible in terms of you have mitigating circumstances. But yeah, as long as you meet the offer most of the time, you'll be fine.
I also got 4A stars, but again, my offer was still AAA, and as long as you meet your offer, you should be completely fine. Like they will not discriminate based on whether you got above or as long as you meet your offer, you'll be fine, basically.
There actually were a few questions about kind of the structure of the program as well. Obviously, I've tried to put in, the modules are all on the website and stuff, but I don't know if you want to talk a bit more about the structure of like your day-to-day life, really.
I would say the law degree here is quite like self-driven. We don't have loads of contact hours. And in terms of lectures and things, they aren't compulsory, and a lot of people don't go because they are recorded. So a lot of people just watch, like I watch the lectures online. So yeah, it's very self-driven unless you've got a tutorial or a class on the day, which is usually once or twice a week. It's sort of just you've got kind of like a reading list, you've got a list of work, and it's just trying to get through everything. So that's like driven by yourself. You have to sort of get yourself up and at your desk or to the library to complete it all. But yeah, it's based on your own timings and how much work you want to do in each day and how many days a week you work.
Yeah, it's very much independent. There are obviously your tutorials, which you have at least once or twice a week, and then lectures that you can go to. But and compared to like sciences and stuff, there is less contact hours, so we have more time to like read our own pace, I guess. We can structure our day the way that we want. So if you have something social in the evening, you can kind of maneuver your like work in the morning, I guess. It's quite nice because it means that you get to be in charge of how you work. And especially I think that I like taking my time with stuff. I've got the hours in the day to take my time.
There's a lot of questions on there about EPQ, which I might pick up. The entry requirements are AAA or equivalent. EPQ is not part of the entry requirements, so it would never be on your offer. That being said, if you are doing an EPQ and it's in law or a relevant subject, then you need to put that on your UCAS application anyway, because it needs to be a complete application. But if then you were shortlisted and it came to interview, they definitely could ask you about your EPQ, but it would never be used as part of the admissions process to like give you an offer or anything like that. But I do think they are interesting for students to do as well. Do you want to say anything about your colleges as well? Because we kind of I very briefly touched on the admissions process and choosing a college and having an open application as well. Did you all choose a college, or did you get reallocated, or do you know what happened to you?
I did an open application and got interviewed at 2 different places. So I got interviewed at Mansfield first and then at New College.
And the interviews went well, obviously, but how did you feel they went when you were actually in them?
Well, I had 3 interviews, so it was 2 at Mansfield and 1 at New College. I thought the one at New College actually went the worst. And to be honest, all 3 of them I didn't think went great. I mean, they weren't really hard or anything. It's just I feel like you always like very critical looking back on things. But I mean, obviously it did go fine. I feel like everyone walks out of their interview going, "Oh my God, that was the worst thing ever." When it usually isn't the case. Like they're not expecting you to be like a top lawyer already, so they're not really expecting you to have like loads of knowledge. And I just slipped up on quite a few things, but again, that's not the end of the world. Like they are expecting you to make mistakes and things like that. So that was why I sort of thought it went bad, but obviously it didn't. So
well, I didn't apply to Mansfield initially, but I think it doesn't really matter where you apply. I mean, it's a good idea to check, like, see which colleges aligns with what you want, but you will find that everyone who's been moved to a different college ends up enjoying it. Everyone loves the college that they end up at. You will make friends at whatever college you go to, and each college does have its own positives and negatives, so it doesn't really matter that much which college you end up in, but still take some time to look at which colleges that you think you might enjoy going to.
There's a question that says, what type of questions do they ask in an interview, and how did you prepare yourself for your interview?
So interviews are kind of whatever the tutor wants to do on that day. So I guess some people got asked about their personal statement. So it's good to know your personal statement. You might get asked about it, like a question about your personal statement. I just got extract of a case and then two judges, like what they said about the case, half an hour before my interview to like look through, and then I was just asked about questions about that. So that mine was mostly like on the spot, what you're thinking, how are you like critically thinking, how are you like understanding and comprehending information such as cases. But sometimes they do really random open-ended questions like about the morality of law. It's really whatever the tutor wants to do on the day and like what they. So there are ways you can prepare, I guess, the on the spot kind of thinking. But my biggest advice for interviews is just to think loudly and think clearly. And it's okay to get stuff wrong. That's not the problem. Just be really clear about what you're thinking, and if you've changed your opinion or if you're still sticking with it, just be really clear so they need to know how you guys think, so they kind of need to also hear it. If you guys just are sitting silent, or they don't like, I don't know doesn't really go well because it's only 20 minutes, and if you just sit there and you just don't know, they can't get stuff out of you. The whole interview thing is just to get how you think and stuff. So definitely participate and keep going. Even if you're wrong, just keep going.
Did anyone else have like an awkward situation in the interview, or how did you feel? Like, was it, because I often say, watch the video that's on our admissions page, and there's a mock one. Obviously that's not the case now because we're doing online interviews going forward, but I always say that it's more of a conversation, and did either of you kind of get stuck down a route and think, oh God, I've actually said this and now I don't believe it anymore? Or
well, yeah, in the one for new college, I was basically the way that they did it, again, you got sent material half an hour before, so it was like a statute and then like a couple of different scenarios, and I basically, I think I was just going in the wrong direction, and I kind of realized that I was, because the tutor was just kind of asking sort of the opposite side and kept asking and asking, and then towards the end I kind of was like, oh, I don't know if maybe I should change my mind, and then I sort of changed the route and answered it sort of in the right direction, I think. But it was, yeah, I think you have to go in knowing that you're going to say some things that are completely wrong. It was a little bit awkward at the time. I was a bit like, oh, and you try to like rack your brain to answer within like what, obviously you can take a pause when they're asking questions just to think, but obviously it has to be somewhat quick fire because you've only got 25 minutes. So yeah, it was just trying to like rack my brain to actually think of what the different scenario could be. But
and then also, they're not expecting you to know anything about law either. So, they're obviously going in, they don't want to put anyone on the spot, and to see someone squirm, that's not ideal for them. They've got like 30 interviews that day. So, but yeah, if you do go down the route which you think, oh gosh, I've changed my mind, change your mind, say why. Say why. Oh, actually now I've considered this, now I'm thinking more it's this way, and it would be this way because, and that's exactly what they're looking for, right? Someone that they can teach at the end of the day. Got some other questions. So what does time between terms look like? Can you receive set work, or is it self-driven? Can you revise but you do not have required tasks to submit when you return, that kind of thing? So what do you do on your off time?
So basically after your term you have a vac, we call it a vacation, and it's basically I think 5 weeks. But we have exams every term. Exams being, they're called collections, and they're kind of just mock exams of what you've done the previous term. So everybody revises for those. So over the VAC, you kind of just revise for those collections. And then some tutors will give reading and essays due for as soon as you come back in. So you do that over the VAC, but you're never not busy. Sometimes you don't even have time in your term to finish everything. So sometimes you use your VAC to be like your catch up on everything, because there is so much to do. Sometimes you just need the vacation to catch up.
Yeah, you need time to rest as well, right?
Yeah. Go to sleep as well. Catch up on your beauty sleep. Yeah, important.
Well, it's not a question, it's more of a statement. I guess it's a question at the end. It goes, I got accepted for Unique, which is awesome. This is great news. It's a university driven program. It's online and it's a residential as well. it's an amazing program, so I think you'll really enjoy yourself on it. And it says, what other programs do you recommend? Did any of you do any kind of outreach programs before you came, or did you just come straight to Oxford without any of that prep?
I did an online summer school with Cambridge, taking us through like a particular topic in land law, and I used that to write about in my personal statement. So I just mentioned it and then talked a little bit about more of the points that they made and how it related to why I'm interested in law.
I did Opportunity Oxford, which is like a program that when you get your offer from Oxford, you get an invitation to like be a part of this program. It's for people from disadvantaged backgrounds or areas, and it's kind of you get an online section. Well, for me, it was an online section where you read up on cases and you have like a reading list that you write essays on. And then you have a 2-week residential in September before you come in October. And it's kind of like a mini, like 2-week, like insight into what a uni student is. And it is really, really fun. You get to do loads of activities, loads of like social stuff. You get to meet people. It's a really good, like, you get to used to the city before you come in October. So it's a really good, like, way to ease yourself into it, because it is a big, well, it's not a big city, but it is a different environment. So it's nice to have those 2 weeks to, but yeah, that's what I did.
There were a few questions earlier on in the session that were more kind of directed towards like finances and how you fund yourself whilst you're at university and if you're allowed to get jobs. So like, does one of you want to step forward of kind of like how that works?
I work for like New College, so I work for New College Step Up, which is like an outreach program. It's just, I think it's 10 hours a term or something. We're also sometimes do some out of term stuff like this, like residentials and things. But yeah, that's kind of like a way to earn a little bit of money during term. And there's also, I mean, I think sometimes it's college dependent. There's some university wide like grants, but I know at New College there's quite a lot of financial support. So like every term or so, or they bring out like grants and things that you can apply for if you're running low on funds.
Yeah, and there's also the Crankstart scholarship as well, bursary. So that's, I never get the amount right, but it's for students that have a family income below a certain amount automatically. How much is it?
It's like 20 something, I think. 20,000, sorry, 20,000 something.
I'll try and find the link and put it on the chat here, but it's an automatic money that you get given at all the students, so you don't have to apply for anything like that. So that's a great start. There are always options out there, and if you are struggling, there are always people to speak to as well. So I would say, like, obviously finances is a big worry about coming to university, but there is help available for you. The Oxford website is a great place to go and look for loads of these different scholarships too. All the information's there, it's updated regularly, and I think the new finances for the next coming year have just been updated on the website as well. And then also, you know, if you come along to the University Open Days in June 26th and 27th, there's like a tent where full of people from finance that can tell you all this information and kind of support you that way as well. Is there any life outside study? That's the best question.
Oh yeah. We would be zombies if we didn't if we just studied in libraries from sunrise to sunset. We have a lot of fun because we're university students, so there's so much going on in Oxford because it is such a student city. There's always plays to watch, there's always plays to actually be in, there's loads of societies that do some really cool stuff. So I'm part of archery, which is really weird and really cool, and I don't think I'd ever do it anywhere except in Oxford. But there's loads of really cool, there's fencing, there's really cool sports that you've not even heard of, and even sports, there's loads of cultural societies that you can be part of that always are doing something every single day. So that you always have something that you want to do if you don't want to work.
Yeah, I think that just probably don't listen to the things that you might have heard about Oxford, the like social life that there is here. Like obviously we do a lot of work, but it just sort of means that you have to just be slightly better. You don't have to be organised. As long as you can organise your time. And you're prepared to do some late nights, you can have other days off, other nights off, like there's lots of like nights out, there's like quite a good like night out scene and things like that, so yeah, I think just don't listen to maybe what you might have heard about Oxford, because I know it doesn't, not the best, like the best things I've heard about the social life yet, but they're not true, and I think we'll probably all vouch for the fact that they're not true.
Yeah, there was a question earlier about kind of networking and careers kind of after university. So it was like, does the university help support you find a career afterwards? I would assume that you're all part of the Law Society. Yeah. Do they have networking opportunities as well, don't they?
I mean, a lot of colleges have law societies, so like I don't know, I think every college does, but I know New College has a law society and does like separate things, slightly smaller things, but Oxford Law Society does loads, especially in like the first term every year, and there's literally like about 10 events that go on every week. It's mostly like dinners, like I don't know, like they have like pizza making seems to be a big thing. I don't know why. But yeah, like they have loads of different things, like where they do like a presentation and then networking afterwards, or sometimes it's just an excuse maybe to have a nice dinner that's paid for by a big law firm. So,
and then, you know, obviously events like this too, we have sponsored things for our outreach events as well, where it's a chance to network too. There's a question here about personal statements. There's always questions about personal statements. So our preference with for us, if you're hearing rumors about this certain university says you need to have 70% this and 30% that in your personal statement, then for us it really doesn't matter. So we don't have that rule or anything like that. So if that university you want to apply to as well is saying that, then go with that for your personal statement. You know, that's, if you've heard that for them, go with it. For us, it's absolutely fine. There's another rumor about like not mentioning another university in your personal statement. I mean, I would say you don't really need to mention any universities in your personal statement, because you're selling yourself to like 5 different universities potentially. But you know, if you want to say that you did an outreach event from this university, or you were part of the Sutton Trust Pathways to Law and things like that, definitely mention them. It proves that you've gone out of your way to put yourself out there into this different team, meet new people, learn different things from different events. So it's definitely worth mentioning. There's not really a reason why we'd be like, oh gosh, they said that. Like, we even, you know, you can even say Cambridge on a personal statement and we'll be fine with that. We absolutely would. Every university out there is putting on outreach events, and our aim is, obviously we would love you to apply to us, but we also want you to apply to, you know, a university as well. So if that event is going to get you applying to that university, absolutely fine, please mention it. You're learning skills in every single one of them, so it's all useful for your personal statement. So it says, is doing law at A level worth it? Okay, this is another myth, I think, that schools say universities don't want students to have studied law at A level. We don't have any subject requirements. We prefer students to take things that they really enjoy and excel at. I think schools think that maybe it would be a hindrance for you because you've learned a certain amount, and then we're going to have to relearn the way that we want you to learn it. But I don't think it's true. We look at the outcome, the grades, when we're doing our assessment. I don't think it would negatively impact you in your first year either. So yeah, do it if you enjoy it. If there's something else, then you're choosing which one to drop. If there's something else that you really love, then go ahead and drop law, like if you love something else. Someone else was saying about the EPQ and art. Is it okay if they do something in art? Absolutely. It doesn't matter what subject you take. If you enjoy them and you excel at them, please take them. For us, it's much better, because if you come into a tutorial and it's you and someone else, and that other person's done all the sciences and the maths and like computer science and things, and then you're a very arty person, you've done like photography and other things like that, English literature, that's great, because you're going to think differently to the person that you're in the tutorial room with. You're not both going to have the same opinion, and that's kind of what we want to get. Thank you, ambassadors, for coming on in the evening. I really appreciate you spending your evening with us. And thank you to everyone that stayed online listening to me witter away. They're all dropping away drastically, but there were 100 and something in there at the time. And, you know, come to the open day, see Oxford in person if you can. And good luck with your applications. You know, I hope it go well. Thank you so much.